The fairest judge in cheating cases? I'm Judge Judy Brattle. I graduated from law school at 22, clerked for a federal district court judge for 2 years, became a partner in a law firm 5 years later, and 2 years ago was appointed a state court judge, the youngest female judge in the state. I was 29 when I was appointed, and 31 when this story began. I was picked on a lot in school and at the law firm because, frankly, I have a good body and hips and a decent face. My breasts are nothing special, but no one has ever complained to me. My older brother has a black belt in Brazilian Jiu-Jitsu and taught me self-defense, and I was born tough and got even tougher as I got older. I don't tolerate disrespect from anyone, as 2 of my classmates in law school and one of the partners at the law firm I worked at found out when I hit them with my knee after they touched me without permission. Like most, but not all, other states, my state does not have a separate family court, divorce, custody. I handle these cases in addition to other civil and criminal cases. Family relationship cases are sometimes heartbreaking, but also provide the most opportunity to do some good and be creative. I make sure that all attorneys appearing before me on these cases are well prepared. After the first 2 unprepared attorneys were severely reprimanded, it became publicized. Like all states except Texas, my state does not allow jury trials in domestic relations cases. April 20th, 9 a.m., Courtroom 6E, Dawson v. Dawson. When I was reviewing Dawson's case file before the preliminary hearing, I did not notice Mrs. Louise Dawson's attorney. Mr. Joseph Dawson's attorney, James Litton, was one of the most vile attorneys I have ever had the pleasure of practicing. After the court was declared open, Litton rose to speak. "Have a seat, Mr. Litton. I have a preliminary matter to settle," I said in a nonchalant tone. "But, Your Honor," began the weasel. "What sit down means you don't understand, Mr. Litton. Not another word until I ask you to speak." He sat down. "Mrs. Dawson, would you please come to the lectern? I have some questions for you," I said in a soft voice. She got up and did so. I noticed that she was wearing a very simple, inexpensive cotton dress with no jewelry or makeup. This was in stark contrast to her husband's suit, which looked like it cost $1,000, with an immaculate white shirt and silk tie. As Louise stood behind the pulpit, I cautiously inquired, "Mrs. Dawson, why don't you have a lawyer? This is a very important proceeding, and it is in your best interest to have one." "I can't afford one, Your Honor." "Why?" "Because my husband kicked me out of the house, canceled all our credit cards, transferred all the money from our joint accounts to accounts in his name only, and because I was a homemaker, taking care of our 3 children and not working outside the home, I have no economic options." Litton stood up and said, "I can explain, Your Honor." I banged the gavel. "Mr. Litton, you need to have your hearing checked, as violating my injunction just cost you $100, which you must pay to the bailiff upon completion of this process. The next time you violate my injunction, you will be removed from the courtroom." Litton sat down. "Have you seen your children lately, Mrs. Dawson?" "No. My husband has forbidden me to see them for 6 weeks while this case is pending." "Where do you live now?" "With my aged parents, who do not have the means to hire a lawyer for me." "Thank you, Mrs. Dawson. Please have a seat." I then turned to Litton and Joseph Dawson. "Mr. Dawson, please come to the witness stand and be sworn in. And Mr. Litton, if you wish, you may object to this to preserve the record, but after objecting, sit down at once." "I object, Your Honor, because we did not intend this to be an evidentiary procedure, and I have not spoken to my client about any testimony," Litton said. "Your objection is noted and overruled, Mr. Litton. Mr. Dawson takes the floor." Joseph Dawson felt awkward as he sat down on the witness stand. As he approached, I noticed he had Gucci shoes. As soon as he was sworn in, I immediately started asking questions. I quickly asked him, "Did you kick Louise Dawson out of your house? Have you canceled all credit cards to which she had access? Have you closed all joint accounts and opened new ones in your name? Have you prevented her from seeing the children for more than a month? Have you withheld all funds from her so that she cannot hire an attorney? He answered yes to each question, growing more frustrated with each answer. Do you have 1 minute to explain to me why you took those actions? Because I have information that, she's been cheating on me, he replied, stammering. That's what hearings and trials are for, to determine the legitimacy of whatever information the parties have. You can't unilaterally rule in your favor without dealing with the situation, and it can't be dealt with properly if you've injured your wife so that she can't defend herself. You may return to your seat, Mr. Dawson. After he returned to his seat, I said, The court will recess for 10 minutes while I make some calls. The parties are to remain in the courtroom and have no contact with each other. There is no reason to get up when I leave or return. I went to my chambers and called Wilson and Wilson. Mary Wilson, please. Judge Brattle here. 30 seconds later, Mary was on the line. Hello, Judy. Is this a social call? She answered. No, sorry business, although I owe you lunch. I have a sad situation where a husband has essentially unilaterally excommunicated his wife, and she has no representation. I need one of your assistants to handle this matter. After all, I suppose there will be money found to pay for your services. It shouldn't be gratuitous. Mary laughed. What nerve you have, she laughed. But you're such a naughty boy that you'll never invite me to dinner again if I refuse, so I guess I'll have to accept. What's her name? Louise Dawson. Tell Louise to come to our office before lunch and ask her to call on me. You're quite a gem, Mary, I grinned, signing off. Whatever you say, she replied with a chuckle. I walked back into the courtroom and sat down on the bench. Mrs. Dawson, I want you to go to the office of Wilson and Wilson, 1220 Cedar Street, just 2 blocks away, 8th floor after the hearing is over, and ask for Mary Wilson. Someone from Mrs. Wilson's firm will appear on your behalf, and we will reschedule the hearing for April 30th. In the meantime, within 48 hours, you, Mr. Dawson, will turn over to Mrs. Dawson $2,500. Once all proceedings are concluded, this payment will be taken into account in determining the final economic payment. In the meantime, you will deliver your 3 children to the home of Mrs. Dawson's parents this Saturday at 9 a.m. for visitation until Sunday at 9 p.m. Also, Mr. Dawson, you will deliver all 10 articles of clothing Mrs. Dawson asks you for by the same time on Saturday. I then asked Lytton and Joseph Dawson, Is April 30th convenient for you to reschedule this trial? They whispered among themselves. Then Lytton said, Only if it starts at 2 p.m. or later. Is that satisfactory to you, Mrs. Dawson? Yes, she replied with tears in her eyes. This proceeding is concluded and adjourned until 2:30 p.m. on April 30th. The court will recess until 10 a.m. April 20th, 10 a.m. Courtroom 6E. Simpson versus Simpson. My next case that day was the divorce trial of Mrs. Charlene Simpson against Mr. Jordan Simpson. Harold Skinner, the attorney representing Charlene, is cunning but not dodgy and has a high price tag. Loretta Fields, the attorney representing Jordan, is inexperienced but has potential. I often wonder why, in domestic relations cases, the parties usually hire an attorney of the opposite sex. If there were jury trials there, perhaps it would matter. But the gender ratio of attorneys and parties has absolutely no effect on me or any other judge I know in my state. Charlene was the plaintiff, and Jordan was the defendant. It was easy to see that the parties in this case were almost the opposite of the parties in the previous case. Charlene is well-built and has an impeccable businesswoman's suit, while Jordan's suit looks wrinkled. At least he had competent counsel. While I wouldn't call Charlene a beauty, she had clearly put a lot of effort into her appearance, including not a single misplaced hair, and was therefore attractive. Jordan would probably be just as attractive as her, except it didn't look like he put as much effort into his appearance. Are you ready to begin your opening statement, Mr. Skinner? Yes, Your Honor, Harold said, as he made his way to the podium. I only give the parties 10 minutes each for opening statements in domestic relations cases because I always read all pre-trial documents carefully. Skinner's opening statement was too flashy for the judge, and I thought it had one or more significant flaws. Field's opening statement was poorly delivered, but she touched on a lot more facts that interested me. "Call your first witness, Mr. Skinner." He called Charlene. The deposition went about as I expected, given the parties' pre-trial briefs and the witness's testimony. Charlene was sophisticated and well prepared. One part of the deposition was very important to me. "Skinner, why should you get sole custody of your 2 minor children, Mrs. Simpson?" Charlene, "Jordan is a bad influence on the children. He has no ambition, is lazy, lacks good hygiene, and is unwilling to take responsibility in situations where proactive action is required. He also sometimes doesn't use proper grammar when talking to the children and is not an effective educator, which I think is very important. I would say that overall, he is a poor role model for children, and I would not want them to be influenced by his bad habits and behaviors." Charlene's direct testimony was most animated when she talked about money, specifically the amount of money she needed to support her lifestyle. Apparently, despite Jordan being lazy and lacking ambition, he made a lot of money. I wondered why she wasn't equally animated when talking about her children, especially since both girls were 7 and 9 years old. In total, Charlene's direct questioning lasted about 50 minutes. The cross-examination of Loretta Fields was adequate when it came to money issues, but I was very disappointed with the one about custody. She made attempts, but missed the most obvious questions in my opinion. I got a real sense of what to ask by observing the behavior of Charlene and one particular audience member at the gallery. After the crosstalk, Charlene Skinner said, "No redirecting," and Charlene was about to leave the podium when I said, "Please sit down, Mrs. Simpson. I have a few questions of my own." Neither she nor Skinner seemed to like it, but my job is to ensure that the best interests of the children are served, so I don't care whether the parties or attorneys like it or not. I let them present whatever they want, and I never interrupt them, but when they're done, if something hasn't been brought to a conclusion, I make sure it is. "Mrs. Simpson, you have explicitly stated that your husband is a bad role model. Do you believe that a good role model is important in determining custody?" Although Charlene had the look of a deer in headlights, she pulled herself together and answered, "Yes." "You mentioned a number of your husband's bad habits and behaviors. What standard of comparison do you use in evaluating those habits and behaviors?" In response to this and all my other questions, she continued to stare at me like a deer in headlights. Well, compared to other men I know?" "Which men exactly?" "Well, some of the men in my family." "Anyone else?" "Well, with Arnold Robbins." "Who is he?" "A friend of mine." "Did you have an amorous relationship with Mr. Robbins before the divorce petition was filed?" "Your Honor," Skinner said, standing up, "adultery is not an element to be considered in our state's courts, so I object on grounds of relevance." "Mr. Skinner, there is no prohibition against taking adultery into consideration. Read the law. In this particular case, because of your client's direct testimony that she believes a good role model is important in determining custody, and the bad habits and actions of the parties, I believe it is highly relevant. She explicitly told me that I should take into account role models, bad habits, and actions, so I do." Then, Your Honor," Skinner continued, clearly out of breath, "I will advise my client to invoke the privilege against self-incrimination, since the law still states that adultery is a crime. As you know, Mr. Skinner, no one has been prosecuted for adultery in this state for at least 2 generations, and it is only through the laziness of the legislature that the prohibition against adultery is still in effect. However, I specifically grant Mrs. Simpson and Mr. Robbins immunity from prosecution for violating State Code Section 18.403b. Since I have every right to grant immunity in the interest of justice, Mrs. Simpson must answer my questions. Skinner slumped in his seat. I asked the court reporter to read the question. A very nervous Charlene mumbled, stammering. Yeah, I'm not sure. When exactly the first time we had sex? I'm sorry, Mrs. Skinner, I don't accept that answer. Think carefully, take your time, and answer again. In the meantime, please see to it that the gentleman in the blue suit and pink shirt sitting on the gallery, I believe that's Mr. Robbins, does not leave the courtroom. If you still answer that you don't remember, Mrs. Simpson, I will call Mr. Robbins to the witness stand and swear him in, and his memory may be better. It may also lead me to think that perjury proceedings should be instituted. Robbins looked like he wanted to shit his pants. Charlene was nearly apoplectic. After a 90-second pause during which I just stared at her, Charlene cleared her throat and testified, "Yes, I had an affair with Mr. Robbins prior to filing for divorce." How many times? Again the swallowing motion, again the delay, then, I'm not sure. More than 5? Another delay and a gulp, then yes. You may step out now, Mrs. Simpson. Mr. Skinner calls the next witness. The rest of the day, the trial proceeded as expected. I told the parties to have the 2 minor children in the courtroom at 9 a.m. the next day for a discussion with me in an office where only the attorneys would be present. Skinner objected vigorously, but it did him no good because the statute specifically authorizes the judge to interview the minor children in chambers. I also cautioned the parties not to influence in any way what the children would say. The children's interviews were important only in the sense that none of them said anything bad about either parent, at least nothing of importance. Closing arguments were made between 3 and 4 o'clock in the afternoon of the 21st. I told the parties to come back at 9 a.m. on the 22nd, and I would give my opinion. After talking to the children, I knew how I would deal with the custody issue, but I still needed to reflect on exactly how to deal with the financial issues. The parties were dismayed when I announced my opinion the next day. The main points, the whole decision was much more complicated, were: the parties were awarded joint custody of the children, ages 7 and 9. No child support would be paid in either case unless some major problem arose. I would expect the parties to split the costs in the best way possible. The house in which the children were currently residing was not mortgaged, and the children were to remain in it. Mrs. Simpson was to stay with the children 1 week and Mr. Simpson the next. During one 2-week period when the children were out of school, Mrs. Simpson was to have full custody of the children, and during the other 2-week period, Mr. Simpson was to have full custody. Custody would alternate for major holidays, 4th of July, Thanksgiving, Christmas, and New Year's Day, going from year to year. In making this decision, I have considered all of the parties' activities and propensities for being good role models, as well as bad habits or actions, was my most definitive statement. Neither party could allow a romantic partner to whom they are not married to stay in the house from 10 p.m. one day to 7 a.m. the next. Liquid assets would be split 50-50. Because Mrs. Simpson did not work full-time outside the home but had a college degree in marketing, she would be granted maintenance for 1 year at $2,500 per month, which would stop after 1 year or after she found a job earning more than $60,000 per year, whichever came first. I could see the shock on the faces of everyone in the courtroom. Mr. Simpson's shock was happy, and Mrs. Simpson's not so much. I could make that judgment because there was enough money for both parties to get their own apartment. My final judgment stated, "The parties may come to any agreement that will meet their needs in the future, and, if reasonable, the court will substitute that agreement for this determination. The clerk shall immediately enter this determination into the record." April 30th, 9 a.m., Courtroom 6, E. Dawson versus Dawson. This time, the reason for the preliminary hearing was quite different from the previous time. Previously, it had been held to schedule and ask for a default judgment because Mrs. Dawson had not properly responded to the divorce petition because she did not have an attorney. This time, Julian Groves, a lawyer from Wilson and Wilson, to whom Mary Wilson had assigned the case, asked that a revised answer to the petition be brought, spousal support be awarded for the duration of the proceedings, and joint custody be awarded for the duration of the proceedings. I let Litton, who represented Joseph Dawson, speak first. He rambled on about how due process requires parties to follow the rules, and that Louise Dawson had no excuse for not following the rules. She could try to find a public interest attorney. After Litton finished, I let Groves speak, simply because I wasn't familiar with him and wanted to see if he would represent Louise properly. I had already decided what to do. Groves was actually very good. Not only did he argue eloquently against Litton's proposal, but he made some really strong arguments in favor of his proposal. I allowed Litton to respond to Groves's arguments on his motion, and then informed the parties that I was ready to rule. Mrs. Dawson's failure to fully respond to the divorce petition is fully justified in no small part because of Mr. Dawson's unjust actions in denying her access to any form of support. Therefore, Mr. Dawson's motion is denied with prejudice, and a revised response will be entered into the record. With respect to Mrs. Dawson's motion for support and custody at trial, the plaintiff has not shown good cause why it should be denied. As I said on April 20th, a party cannot unilaterally decide the final disposition of a case. There is a court for that. The only non-trivial reason given by the petitioner for maintaining the status quo is the charge of adultery, which Mrs. Dawson denies in her amended response to the petition. Because even if it is proved, which cannot be assumed at this stage, that adultery occurred without special circumstances, as it was in my recent decision in Simpson v. Simpson, it is not a major factor in deciding any ultimate issues. Therefore, Mr. Simpson will pay Mrs. Simpson alimony in the amount of $3,500 per month until the case is resolved by trial or settlement. Mrs. Simpson will be allowed to move into a mother-in-law apartment above the garage at 29 Mountain Crest Lane, and joint custody of the children will be awarded, to be agreed upon by the attorneys within 5 business days, and if no agreement is reached, I will dictate it. The case is adjourned until a preliminary hearing with counsel, the date of which will be submitted by the attorneys also within 5 business days, but will occur within 3 to 5 months from today. The proceedings are adjourned. Joseph Dawson looked like someone had stolen his basketball on the playground. Louise Dawson looked like she was smiling for the first time in a month. May 16th, 10 a.m., Courtroom 6A, Church v. Pinsky. We convened in Courtroom 6A rather than my usual courtroom because both sides expressed interest in using sophisticated visual aids that were not in Courtroom 6E, but were in 6A. Mr. Laughlin Church was the plaintiff, and his wife, Marilee Pinsky, she retained her maiden name, was the defendant. Neither party sought counseling, and both seemed determined to bring the other side to its knees. They were represented by large firms with competent partners, Robert Dutton of Smith, Harding and Dutton for Church, and Cheryl Norton of Norton, Brooke and Tisdale for Pinsky. These attorneys were sophisticated enough not to play the game with an attorney of the other gender on the side. Both attorneys will try a few tricks, perhaps even some that I haven't seen before, but they won't succeed. Although the motion was filed on the basis of irreconcilable differences, it was clear from the pre-trial briefs and opening statements that both sides wanted to try the case on the basis of adultery, even though that was not allowed under the law. Of course, both sides were aware of my decision in Simpson v. Simpson and tried their best to deceive the other side into giving testimony that would allow adultery to be used against them, but also to avoid falling into this trap so that it would not boomerang. After the first 2 days of testimony, I almost had PTSD. It was obvious that both Church and Pinsky were serial cheaters. Church justified it by trying to prove that Pinsky cheated first. Pinsky tried to justify it by trying to prove that Church was abusive. During cross-examination, it became clear that both had lovers at one time or another in the house they shared, including when their 2 minor children, a boy of 8 and a girl of 6, were in the house. I spent most of the trial directing the attorneys to reassure their clients. The attorneys did their best, but despite their skill and seriousness, they were not completely successful. At the hall meeting after the second day of the trial, I asked both sides, along with their lead attorneys, about other family members. They both said they had parents who were still alive and active and who had been good parents when they were children. Church also had a brother who had been married 15 years, had 3 children, and had no domestic conflicts, and Pinsky had a sister who had been married 7 years, had 2 children, and had no domestic conflicts. I am a very unconventional judge. I recessed for 1 day and, since the parents and both brothers were all local, told the attorneys that although they were not on the witness lists, I wanted them to be in court the day after tomorrow to testify. Norton objected strenuously. Your Honor, we made a reasonable decision not to call my client's parents or sister to testify, and you have no right to impose your will or strategy on us. Dutton was less forceful, but agreed with Norton, perhaps for the first time during the trial. Judge Brattle, none of the people you mentioned have any meaningful testimony to present to the court. They have no knowledge of the party's finances and are unwilling to offer their opinions on any matters. Ms. Norton and Mr. Dutton, you have cited no law or precedent that says I have no right to call my own witnesses, even if they are not relevant to the parties. I give you until 11 a.m. tomorrow morning to bring such evidence. If not, all 6 will be in court the day after tomorrow at 10 a.m., unless they have a legitimate medical or business conflict, and don't try to pull any funny business. Both sides and the attorneys walked away furious. I must be doing something right, I laughed to myself, as they, muttering, left my chambers. Neither side had been able to cite a single legal document to support their position. Dutton presented nothing. Norton presented some obscure decision from France, which I rejected out of hand. On the next day of the trial, I allowed the parties to complete their pleadings and then questioned both parents and siblings without the presence of others in the courtroom. My goal was to find out what they knew about their family members' infidelity, what their own family life was like, how they could help their family members, and how receptive their family members were to receiving help. Church ended up being very angry because his parents did not know about his cheating and found out in court. This made his mother very upset. Both parents were good, decent, honest people. Church's brother tried unsuccessfully to convince Church to stay true to his vows, regardless of what Pinsky had done. Pinsky's parents were decent people, too. Pinsky's father broke down when he testified about having a one-night stand when his daughter was very young. He told Marilee Pinsky about it and begged her not to go down the path of adultery, as the one-night stand was the biggest regret of his life. Marilee Pinsky's sister broke off contact with her because of her adultery and didn't want her children to know about Marilee's boyfriends. Closing arguments were over by 4 p.m., and I advised the parties to return the following Monday, and I would render my decision. When the parties reconvened, I was stern. I find that both the plaintiff and the defendant are evasive in most cases. I therefore rely primarily on expert witnesses regarding the financial issues in this case. I order that the liquid assets be divided exactly as proposed by Mr. Church and Ms. Pinsky, which is specifically set forth in my written opinion to be delivered after my oral argument. With respect to child custody, both the plaintiff and the defendant have serious issues that concern me. I wish very much that I could award custody of the minor children to Mr. Church's brother or parents, or to Ms. Pinsky's sister or parents. However, that is not within my power. What I can do is ensure, to the extent possible, that some of the problems that have arisen in the past do not recur. I award Ms. Pinsky to occupy the family home, but she will pay half of the mortgage, which is fortunately small compared to the value of the house, and half of all utilities, including landscaping, until the youngest child turns 18. After that, the house will be sold and the proceeds divided 50-50 unless one of the parties buys the house for a mutually acceptable amount. The parties will have joint custody. Initially, the custody will be 50-50, but it will depend on several conditions in the future. The first condition is that neither party will have a romantic partner in their home between 10 p.m. and 7 a.m., when one or both children are around, unless they are married to that person. The second condition is that both parties will attend parental counseling sessions to ensure that there is minimal negative impact on the children due to the obvious rage that the parties display toward each other. Counseling will include at least 3 sessions individually and at least 2 sessions together, using a counselor from a court-approved list of service providers. If either party violates these terms, custody will be modified after evidence is presented to the court to allow more time for the affected party. More than 2 violations will result in sole custody being awarded to the aggrieved party. Judgment will be entered today as ordered. Surprisingly, both sides were more optimistic than at any other time during the trial. I could actually see smiles on the faces of both attorneys and both parties. Both parents were in the courtroom at the time, were clearly friendly with each other, and seemed relieved by my decision. Could it be that I had actually done something right? July 15th, 10 a.m., Courtroom 6E, Dawson versus Dawson. At the beginning of what was to be the first day of trial, I had to deal with a motion for summary judgment, filed by Louise Dawson's attorney, Julian Groves, on the issue of adultery. Documents submitted by the parties included the testimony of a private investigator who had received a statement of arousal from a questionable person who reported that Mr. Dawson had paid him to spike a drink that Mrs. Dawson was using, and then took pictures of Mrs. Dawson essentially being taken advantage of by a man he knew only as Rock, while Mrs. Dawson was under the influence of the drug for use on a date. Obviously, these allegations were very troubling. Before the motion for summary judgment began, I invited both parties and their attorneys into my chambers. Let me say to all of you bluntly, if I find that the private investigator's testimony is an exception to the publicity rule, and I believe it is, I will not only rule in favor of Mrs. Dawson on the issue to which summary judgment applies, but on many other issues as well. In addition, I will refer the case to the prosecutor for action. On the other hand, if I find that the testimony is not proper evidence or do not believe it, it does not bode well for Mrs. Dawson. Furthermore, I must advise you, Mr. Dawson, that your previous attempts to deprive Mrs. Dawson of a defense will work against you, and no amount of testimony in your pre-trial brief will convince me otherwise. In conclusion, this case should be settled. I am postponing the trial for today for 1 more day. At 10 a.m. on Wednesday morning, if the case is not settled, I will take testimony on the motion for summary judgment rather than simply relying on the parties' submissions and then proceed to trial immediately. You have to settle. Obviously, Mr. Dawson got religion into his head. I'm sure he didn't want to risk me taking the private investigator's testimony and believing it, since he was a successful businessman, and that would have been devastating to him. By 10 a.m. on Wednesday morning, the parties had reached a settlement agreement. In my opinion, Mrs. Dawson could have gotten more, but I wasn't going to give up the settlement if she could live with it, so I entered it as a court order. After a quick succession of Dawson, Simpson, and Church cases, I didn't have much time for domestic relations cases. I went to see our court's Chief Justice, John Anthony. Entering his office at the end of the day, when the Dawson case was completed, I sank into the chair across from his desk and wailed. I'm sick of domestic relations cases, John. I know they are supposedly randomly assigned, but I see your hand in my recent appointments. John didn't deny it, he only grinned. But you handle them so well and creatively, Judy. I hear that your decision in the Simpson case has not only already become famous, but that a continuing legal education course is based on it. How fun, I hummed. Please, I need a break from them for a couple months. I've just been assigned 2 new ones. Okay, belly button, John laughed. I'll reassign the 2 recent domestic relations cases to Quentin and Morris, but from now on, whatever comes up in the rotation, you'll have to live with it. Thanks, John, I said with a wide smile, and walked out of his office. I was emotionally drained for the rest of the week. But I got to work on other civil cases until at least 5 p.m. that Friday. At 4:58 p.m. on Friday, I got a call from the receptionist saying, "Judge Brattle, Detective Philip Brubaker is here to ask you to sign a search warrant for a murder case he is working on." Despite my fatigue, I smiled. Phil is better looking than almost any detective on TV or in a movie. He is about 6 feet 4 inches tall and weighs 220 pounds. He's 30 years old, a year younger than me, and he became a detective in almost record time. What an asshole, I grinned to myself. "Thanks, Jen," I said to the receptionist. "Listen, why don't you leave right now? It's almost 5 o'clock and I don't need you anymore today. Just make sure the outer door is locked. Let Brubaker cool his heels until you're ready to leave, then tell him to come in." "Hello, Judge Judy," he snorted. "Here's what I need you to sign," he continued, dropping the document on my desk. "It's not a search warrant, asshole," I snorted back. "What is this? This certificate of injection? Is that a legal document?" "Yeah, it's what guys like me use when they want to punish a dumbass and don't want some lame lack of consent lawsuit filed against us," he smiled. "So what is it about this nasty fool you want to punish, and why do I have to sign this document?" I snapped back. "You have to sign it because you're a nasty fool," he grinned. Brubaker then walked around my desk, lifted me from my chair, and sank his lips into mine, with what felt like half a dozen of his hands roaming all over my body. Noticing my lack of underwear, he interrupted the kiss and said, "Wow, you really are a nasty fool, aren't you?" "Less talk, more action, asshole," I replied pleasantly. Brubaker deftly swept the notebook still resting on my desk and laid me back on my desk. We made love next. After a few minutes, he said with a big grin on his face, "There's nothing like a piece of the judge's body on her desk." I punched him lightly in the stomach and said, "You're talking about Judge Ginger Stevens, asshole," I snapped back. Ginger Stevens was a wrinkled 80-year-old woman who should have retired 20 years ago. "Given that attitude, I'm not sure I'd invite you to my apartment tonight," he grinned. "You will if you want some more prime bod, detective," I snorted, getting up from the table and kissing him on the lips. "I'll see you there in 20 minutes, he grinned. "In 30, it'll take me 10 minutes to recover from what you just did to me," I grinned. Another quick kiss, and he was gone. As you can easily see, I loved having sex with Detective Brubaker. After a quick dinner that night at his apartment and a leisurely swim in his huge, I had sex with him. After waking up around 7 in the morning, I changed into my workout clothes that I had brought with me and got ready to go to the gym. I work out at the gym 4 days a week, especially on Saturday mornings. Phil hissed as I was about to leave. I gave him a quick kiss and deftly dodged his strong hand trying to pull me back into the sack for another sex session. After missing, he looked at me with a sincere expression on his face. "Why don't you want to marry me, Judy? It's not like we could be more compatible sexually, and I really want a family." "I'm sorry, Phil. Like I said, the last 4 times you've asked, handling divorce and custody cases has bored me. I can't go down that road. If I'm going to be with anyone, it's going to be with you." I smiled. "Come a little closer and you can experience a little more magic," he grinned. I replied, "Yes, yes. I need to exercise to keep my girlish figure," and walked out. Yes, judging divorce and child custody cases has made me cynical about marriage. There have been too many trials like Dawson, Simpson, and Church. I would have liked a long-term relationship with Brubaker, but I knew he wanted a family, and I realized when he started dating a nurse, and they married about a year after our aforementioned sex. 3 years after Phil Brubaker married, I was assigned a domestic relations case, Brubaker vs. Brubaker. In reviewing the case, I became very frustrated. Fortunately, I was able to convince Chief Justice Anthony that the case presented an ethical conflict for me and it was reassigned. I did not follow the trial. The end. Subscribe to my channel. Thank you.